As the nature of economies shifted away from pure agrarian and crafts to mercantilist, a broader audience had an interest in understanding not just general areas of law, but the law of companies in particular. A growing body of experts was emerging to address this need. The growth of the merchant class and the further evolution of an organized legal profession created considerable demand for clearer guidelines regarding the creation and operation of corporate entities. As the number and influence of the companies grew, company law became a legal field in its own right, and there was an increasing need for expertise in this area of the law. Luckily, some of the leading English jurists of the day became active to fill that void. And to explore that topic, we need to move on to our next location. The bells don't always ring. In the late 18th century, Sir William Blackstone published his famous Commentaries on the Laws of England. Blackstone was a leading jurist of his day and had a career which extended from private practice to the bench to academia and politics. The commentaries have their roots in a series of lectures which Blackstone gave at Oxford in 1753, known as the Venerian Lectures. These covered a whole range of topics of the common law, including the law related to corporations. Elaborating on some of the points raised by Coke a century and a half earlier in the Sutton's Hospital case, Blackstone identified 5 things considered necessarily and inseparably incident to every corporation which has been duly formed. These are: 1. Potentially indefinite succession. 2. A corporate name under which it could do all acts as natural persons may, including to sue and be sued in court. 3. To purchase and hold lands for their benefit and for the benefit of their successors. 4. A common seal in order to unite the several assents of the individuals behind it into one joint assent, and thus manifest the intentions of the corporation. 5. Bylaws or internal statutes to govern the corporation. These were to form a sort of political reason to govern the body politic, as a proxy for the natural reason which natural persons have. Conspicuous by its absence, just as with Cook's list of essential elements, is any mention to a right to limited liability. Neither jurist writings considered this an essential element or necessary and inseparable incident of a properly formed corporation. So what did Blackstone say about the nature of the liability of legal persons under English law as it had developed to this point? Nothing directly, it seems, though quite a bit indirectly. In both the full text and a question and answer format of the commentaries, Blackstone notes that the debts of a corporation are extinguished upon dissolution. He even cites the Roman law maxim we heard earlier in supporting this statement. that which the group owes, an individual in the group does not owe, nor does the group owe that which the individual owes. This brief section comes at the end of Book 1 of the 4 books of the commentaries. It seems to support the school of thought which claims that limited liability is indeed part and parcel of the corporate form. But upon closer inspection, that conclusion appears premature. First, the explicit reference to debts describes a specific type of obligation a corporation might have. In the vernacular of the time, as well as today, the term seems to relate to monies borrowed or provided, such as for the support of the underlying purpose of the corporation. This more narrow interpretation of the term debt says nothing about other types of claims not arising out of a debtor-creditor or investor-investee relationship. This distinction shall become more important when we reach the period of industrialization. Second, and equally important, dissolution is a specific and extraordinary event in the life of a corporation whose default position is one of indefinite existence and cessation of corporate property. To see why this is so, we can focus on the rare and somewhat extreme circumstances which justify or call for the dissolution of a corporation as described by Blackstone. One, by Act of Parliament. 2. By the natural death of all its members. 3. By surrender of its franchises into the hands of the king. 4. By forfeiture of its charter through negligence or abuse of its franchises. The first and third situations are arguably two sides of the same coin, and hearken back to the essential requirement highlighted by Cook of lawful incorporation. Dissolutions were not always negative events. Achieving a specific limited corporate purpose, such as the construction of a bridge or highway, could also trigger dissolution. Blackstone reminds us that original authority for any act of incorporation resides with the king, even if another body takes care of the administration. The king's consent, either expressly or impliedly given, is absolutely necessary to the erection of a corporation. The second situation reflects the general small circle of participants in acts of incorporation at the time. One or more grantors of property to support the collective cause, and those who should take responsibility for pursuing the corporate purpose. The general rule remained indefinite succession, with replacements for any natural person participants upon their death or the discontinuance of their involvement. Finally, the forfeiture situation again highlights the importance of the corporate purpose. Actions clearly inconsistent with that purpose could lead to the invalidation of the corporate charter, thus ending the legal fiction of its separate existence. We shall return to this concept later on in the lecture. Whatever the cause of dissolution of a corporation, the default rule regarding corporate property was the same: reversion to the original donors, or alternatively, to their heirs. Any dotation or endowment of property to the corporation was tied to its corporate life. Thus, if this came to an end as a result of dissolution, the property would revert to the grantor. We will visit these fine points of the law in the ensuing centuries to see how the analysis is applied in later contexts. That would also include application in the context of a new nation which emerged just a few decades after the publication of Blackstone's commentaries.